That's right. I forgot. Phone war stories to the law clerk, to the intern. They're so nice and they laugh so much. I remember when I was elected, they go, everybody's going to laugh at your jokes. They're not any funnier. It's just, Good morning. I apologize for being a couple minutes late. Really don't like doing that. Anyway, this is the matter of the David Krieger et al. Versus Department of Environment, Great Lakes and Energy et al. It's our case 20-94 It's my privilege to be here today. Jim Redford, I'm the Court of Claims judge assigned to the case. This is the regularly scheduled status conference in this matter. We're continuing to work together. Our court reporter today is Megan Price. I don't see her, and I think we had a lot of folks who indicated they would be attending. Hey, Ms. Price, how are you? Okay, good to be welcome back. So it's we have a number of attorneys who are appearing remotely, and then looks like all right, the box score is starting to fill up. I feel like I'm watching a Tigers game or something. Got to see two of them last week, one in person. After Mr. Dubin yelled at me when I was in oral arguments last, or no, that I was yelling at you. I'm sorry. Judge
Krieger who was yelling. Wasn't me.
Sorry. I had Court of Appeals assignments last week. Had the privilege of serving with Judge Bozzi, the newest judge of our court, and Judge Reardon, a longtime and dear friend from when we were both back in the U.S. Attorney's offices in the Eastern and Western District. And I don't think Judge Reardon yelled at anybody during your call. It might, maybe some other cases, but Mr. Dubin had a very interesting case involving the Great Lakes Water Authority in the city of Detroit that we enjoyed your presentation. It was nice to have seen you on something other than this matter, but it's always good to see you on this one too. All right. Pardon me?
It'd be nice if we just carry over to Detroit.
Oh,
take this to Detroit. If you could go to Detroit.
Right. No, well, no, it's a legitimate observation. We're not going to be trying this in Detroit. I had seriously thought about and had actually planned that we would try this in the 17th Circuit on the 12th floor. And I talked to the then chief judge and indicated that it'd be fine. I talked to the current chief judge last August, and she also indicated it'd be fine. And then my staff and I talked about it and just decided we're doing a month-long trial. We're going to do it in our courthouse. The legislature decided that the Court of Claims is going to be situated in the Court of Appeals. We're not going to be doing on the road shows for our trials. So not of that length anyway, but so that's where we're at. So today's time and date for 10 o'clock was the time, started at 2 minutes after 10 for the status conference. Let's have appearances from plaintiff's side of the V for who's in the courtroom, and then from defendants, and then we'll go on to in from there.
Good morning, Your Honor. Christopher Desmond from Ben Johnson Law on behalf of the mass action plaintiffs.
Okay.
Dave Dubin from Dubin Law here on behalf of the class plaintiffs.
Morning, Your Honor. Jason Thompson on behalf of the class.
Okay. Behind the bar.
Good morning, Your Honor. Kevin Carlson from Pitt McGee from Mass.
Good morning, Your Honor. Elizabeth Fagan on behalf of the class plaintiffs.
Okay, thank you. All right, that's who's in person. And then Ms. Price, if you can't, did you hear the last two? It was Mr. Carlson and Ms. Fagan?
I'm sorry to interrupt, Your Honor. The first two I couldn't hear from Ben Johnson. The first two, sorry to bother you.
Sure, yep.
I apologize. Christopher Desmond from Ben Johnson Law on behalf of the mass action.
And those mics are, you can pretend you're at a karaoke night if you want to before we start the actual trial. It was always interesting as a trial judge, we had in 17th Circuit, remote wireless system. And oftentimes jurors would use the headsets. And invariably you'd be charging them every time you're not in trial, and then you'd start up and 3 minutes into something, they stop working. It's just like, it's the ghost of the trial courts. So apparently they continue in this building. What we're doing, Ms. Price, is trying to get the handheld microphones with new batteries.
You asked me to repeat myself. I'm Sharon Elman Road at the Miller Law Firm for Advanced Management Players. Did you hear that this time?
Yes, thank you so much.
Thank you, Ms. Price. All right, and then Dan Cramner is our security director who's here with us today. And if we could hear from the defendant's side of the V.
Good morning, Your Honor. Danielle Allison Yocum on behalf of the state defendants.
Thank you.
And good morning, Your Honor. Richard Cole on behalf of the state defendants.
And Nathan Gamble, Your Honor, on behalf of the defendants.
Thank you. All right, good. All right, so I don't think anybody submitted specific agenda items like we've had for the last days. We've joined one another on the regular schedule. Is that right for the plaintiffs? Okay, defense? That's correct?
No, we did not submit any, Your Honor.
Okay, great, thanks. So I have some notes that I've gone through. I've had the opportunity to spend, just like everybody else, a lot of time getting ready for today and continuing to get ready in this case. Let me just. That was the two things that bothered me when I was a trial judge was being late and cell phones going off. Since I've already violated one of my own rules this morning, I'm gonna make sure my cell phone is off so that I keep it here because I need to use this to access a 6-digit code or an 8-digit code if I need to get into the court's computer system while I'm up here, because while I have a screen, I don't have access to my computer unless I do it through my iPad. So that's why I have my cell phone up here. I'm not ordering pizza, nor am I speaking with my granddaughters, although I would much prefer doing that than anything else I get to do in life other than be with my own family, my immediate family. But if I'm looking at my phone, it's because I'm getting ready to go into the computer system. All right. So we've had our appearances. We have no agenda items. What I'd like to sort of go over is what are our pending motions? What are our schedules on them? Then some other future dates. And then I am prepared, if the parties wish to present oral argument on the plaintiff's motion, the defendant's June 6, 2025 motion to exclude the proposed expert witness that was responded to on July 10th, and then a reply brief by the defense on July 16th. I'm also comfortable. We're going to have another hearing 2 weeks from today on a Daubert on that same witness. So what I'd like the lawyers on both sides of the V to think about is, do we want to spend some time doing preliminary arguments on that issue today? And if we do, I'm very comfortable doing that and I'm prepared for it. And I read with great interest the submissions by the parties in preparation for today, as well as memorandums from Ms. Husa, the court's commissioner who's helping me in this matter, as well as others, or whether we should wait until sometime 2 weeks from now to do oral arguments. So just think about that. So right now I've got in my notes show the motion to exclude is pending. Defendant's motion under 2116C10 filed June 20th, responded to July 24th, and with a reply brief of August 1st, 2025. Those are pending. We also have the court issued its trial order on July 10th, 2025. I'm going to be amending that order in the following ways. At paragraph 5 of that order, I indicate that pretrial non-dispositive motions are due 30 days before the commencement of trial, which would put it to December 12th, 2025. I want to advise the parties, and I'm gonna, once I'm done with my comments, I'm gonna invite both sides to talk. But I think I need to move that date to November 21st, 2025, with responses due December 1st, 2025, and setting oral argument on any potential non-dispositive motions for 8:30 a.m. December 5th, 2025. The reason for that is on December 8th, I begin a trial in case 22-076, which is the matter of RJR versus the Department of Treasury, that is blocked out for 2 weeks. And I don't want to try, I just don't know if I'll have capacity to do oral argument while that case is going on. It involves a fairly complicated tax question involving a lot of evidence. And I don't want to be that judge that orders you to appear on Christmas week, regardless of what your religious affiliations are. The 23rd and the 24th, I think, are I guess state holidays this year are the 24th and the 25th. And then there's 2 state holidays, the 31st and the 31st December and the 1st January. The bottom line is we're starting the trial on January 12th. I've got case call in January. I have case call in December on the 2nd and the 3rd for the Court of Appeals. I have case call in January on probably the week of the 5th. And then we start our trial on the 12th. So, and if it's a preliminary matter, I don't think I'm doing anybody a favor if I wait to make a decision until a week before trial. So, at least that's been my experience when I tried, cases in the Justice Department. I always wanted to know what time of day it was going to be 30 to 45 days ahead of time. And that's why I'm going to change that. And I'm going to be happy to listen to suggestions if people think that's a bad idea. The other things I would like some input from council on. Right now, we're scheduled to be together on Monday, 25 August, 2025, or that time period is reserved for a Dalbert hearing. As I was looking through my notes and through the calendar, excuse me, I've got the whole day blocked off for that. We also have tentatively reserved Monday, 15 September 2025 for oral argument on summary disposition motions. And the question to me is that I'm thinking of is, should we carve out, how much time do we need for the Dalbert? Do we need 8 hours? Do we need 16 hours? Do we need 4 hours? And I just don't know the answer to that. My guess is we don't need 16. But I don't know if I've ever seen a witness that takes that long. But this obviously is a substantial witness that the defendants do not believe is qualified to testify. So we're going to have a hearing. Do we block out 2 or 3 hours at the end of the day to do oral arguments on the motion to exclude and the motion for summary disposition? But anyway, I'm going to look for what you all prefer. And then I'll make a decision either here in court. More likely I'll consult with our intern and our law clerk, our commissioner, and then issue an order later on, not today, but sometime later this week. So anyway, that's sort of what I've got on things that I wanted to talk about while we're together. Plaintiffs have the burden of proof. Happy to listen to what the plaintiffs might wish to provide and what your thoughts are on the issues that I've just addressed. Who's going to speak for the plaintiffs as we get started?
I want to address the daughter hearing first, and Mr. Desmond will add to that. You had asked us to find out Mr. Sturtevant's availability on the 23rd or the 25th. He's coming in from Colorado if necessary, the 25th. I hear the court saying 16 hours.
If we're not done, I'm gonna hold them over. My guess is we're gonna be done. I can't imagine we're gonna take more than one day. I mean, and I am very happy to go well into the night if Dan says we can do it. I literally have transferred from US Navy ships in port, gone out, tried cases at sea until the middle of the night in Sea State 3. So, I mean, I'm very comfortable going to midnight. I sincerely doubt we will need more than 8 hours for this. I'll have read the deposition transcripts. I've already read all the pleadings, so, but if we're continuing to go, my expectation will be your witness is going to be Stan.
Because I don't know that was clear to him from us originally.
That's fine. But I'll order him to stay and that's fine.
I can't see it going.
I would be stunned almost beyond belief. I've told you all a million times, 40 years a lawyer, this is not going to be more than an 8-hour hearing. How many times can he ask, are you sure about, I mean, this is not the jury trial. This is a qualifications hearing, so I really don't think it's going to be an issue, but you might want to tell him to pack an overnight bag. So, okay. What about all the other stuff I talked about?
So, Your Honor, my understanding was that Ms. Almanrod was preparing to do the status conference today. I was here if the court wanted to address any arguments regarding the motion to bar Mr. Sturtevant. We were here today prepared to have that argument.
Great.
I understand now from the court's statements. So we came today with the impression that the court had not yet decided whether or not it felt that a Daubert hearing was necessary on this motion.
Right.
Our personal position, of course, is that it's not. We believe Mr. Sturtevant is well qualified and this court can rule that today.
Right.
To the extent the court wants to hear any arguments regarding that motion, we're here today willing to present those.
Okay. How long do you think you need? Maybe 20 minutes, half hour?
Frankly, Your Honor, it's the state's motion. And so it kind of depends on how things go with the
Okay.
state and where.
Are you all ready to argue that?
Yes, Your Honor, Nathan Gamble with the defendants. We are ready to argue the
Great.
Sturtevant motion today.
Okay, good. We'll do that after we go through this first set of housekeeping then. Good. Anything else from defense or sorry, plaintiffs?
For some disposition, I think having a hearing on the 25th, because we were not here to argue today.
Right. No, I'm not asking that. I don't want argument on the SD today, but I'm just wondering if we can graft, assuming we're going to be together on August 25th for a hearing, can we make economic use of everyone's time by also doing the oral argument for any pending motions at that point? And I guess that's what I want people thinking about.
I think it would be worthwhile to at least pencil that in. If Ferdinand goes longer, should the court decide to have this, then, we can then at that point reassess.
Okay. All right. Sounds reasonable. Yes.
Morning, Your Honor. Jason Thompson again for the class. One item that didn't make your agenda was entry of our order, our proposal.
Oh, thank you. That's because I didn't look at the notes that Ms. Husick gave me because she said you need to address that. So yeah, what's your, yeah.
Okay, so we did a brief outline of the notice plan. We submitted it to the court as required under the order.
Yep.
Yeah, it's in the form of a proposed order. And as soon as you enter that starts the clock ticking for us
Okay.
to get the long form notice and the short form notice to you. It's just kind of a housekeeping matter. We need
All
to
right.
get that plan, that order entered.
Do you all have any issues with me issuing that order that was provided?
No, Your Honor.
Okay, let me have just a minute. Elizabeth, can you come up on your side? All right. That order will be signed this afternoon. So thank you. And thanks for bringing that to our attention. Anything else from the plaintiffs? Individually or collectively? Okay, from the defense.
Your Honor, just to clarify, you're asking for our input on whether the motion for summary disposition should be heard after the Sturtevant hearing on the August 25th?
Right. Right now, we penciled in and I'm asking for input on anything that I or plaintiffs have talked about. Before we transition into oral argument that you'll lead, the charge on, first on your June 6th motion. But yeah, so I'm asking about that, for SD. Do you want oral argument?
Yes.
Oh, well, such a surprise. And, okay, and then the question is, do you think that we would be in a position to do finish up whatever, if I think I either need or desire to give the parties the opportunity to give brief additional arguments regarding Sturtevant after the 25th testimony, which is, in my mind's eye, what I'm thinking is we take 3 to 6 hours, 3 to 5 hours of hearing. We take a recess for half an hour or 45 minutes, and then I allow both parties to supplement their arguments for maybe 15 or 20 minutes each on the Sturtevant motion to exclude that you all filed on June 6th. And if time allows, then to push into the summary disposition arguments that from your June 20th motion. That's sort of, as opposed to waiting and then making everybody come back again 2 weeks later on the 15th, just to try to make it so, because as Mr. Dubin said, of course, I'm not traveling to Detroit or Lansing to any of your guys' homes, but we're coming to GR. So that's what I'm thinking. What are your thoughts on that?
We
Also have a seat.
defendants, we are open to that. And so we would, in our motion regarding Sturtevant, it's focused on those 5 opinions. We think that the examination can therefore be fairly focused and efficient. And so certainly we'll be ready after that hearing, if the court decides it's necessary, to argue the motion for summary disposition on August 25th. And even if the court, after the after the motion hearing today, decides it doesn't even need to hear from Mr. Sturtevant, we would still be fine moving the hearing date for the dispositive motion to August 25th, rather than just push it out to September 15th.
Okay,
So
thanks. Good. All right, Mr. Desmond.
Yeah, Your Honor, I was simply going to say that I don't know how the court typically approaches Daubert hearings, but to the extent that the court could wish for there to be supplemental briefing following Mr. Sturtevant's testimony that day, it may be.
It's highly unlikely.
Okay, I just wanted to reserve that possibility. for the
Many
court.
forests have been felled in support of the prosecution of the claims and the defense of them in this matter. If we don't need additional briefing, which I don't suspect I'm going to, yeah, then obviously that affects the time. And if I decide I want subsequent briefing, we're not going to do oral argument. I'm going to say, okay, I want briefing, and your arguments are limited to 5 pages, and have a great day. We're all done.
Understood.
Or words to this effect.
Yeah, thank
So,
you.
great. Okay. All right, good. Then let's move to the oral argument on the defense's motions filed on June 6, 2025, replied to on July 10th, and then, responded to July 10th, and then replied on July 16th. I just need to grab 2 of my binders. My staff is now, in this case, every month has its own binder. So it makes it a little bit easier to find stuff. And thank goodness for Mrs. Tomet, every month the binder has a guide and it's tabbed. And so I know like where to look. So Mr. Gamble, let me turn to, let's see. Attachment 1 for June.
thank you. Good morning, Your Honor. May it please the court, Nathan Gamble here on behalf of the defendants. In our motion regarding Mr. Sturtevant, we asked for 2 alternative types of relief. We think the first relief the court could provide is based on the fact that Mr. Sturtevant did not draft his own expert report. Just from reading the report, it's plainly written by attorneys, and he confirmed in his deposition that he does not even know who drafted the report. He simply reviewed it and signed it. And for that reason, we don't think it complies with the court's case management order, which requires experts to prepare their own reports. And really, that's a line that shouldn't be crossed in general. Anyway, lawyers shouldn't be writing their experts' reports. And so we think that that's one basis by which the court can prohibit the plaintiffs from relying on Mr. Sturdivant's testimony. But the alternative request for relief is simply that the court rule that 5 discrete opinions that Mr. Sturdivant have offered are not admissible. The Court of Appeals in this case has already identified the facts that the plaintiffs will need to prove in order for their claim to succeed or proceed. Mr. Sturdivant has no personal knowledge of any of the evidence around any of those facts. So relying on his testimony would violate the most basic rule of evidence, which is that witnesses need to have personal knowledge of the topics they're testifying about. The exception to that rule is MRE 702, which allows for expert witness testimony. But that rule is a crucible, especially after the Supreme Court modernized it in 2004. It is a demanding standard that the plaintiffs have the burden to satisfy. And the rule is not difficult to read or understand. It's very plainly written out. And for each of the opinions Mr. Sturdivant has proposed, the court is required to determine that each of those opinions satisfies each of the factors under the rule. So if we turn to the first opinion that Mr. Sturdivant has offered, his opinion is that the defendants operationally controlled the Edenville Dam. Well, he had no involvement, of course, in the Edenville Dam. So in order for that to be admissible under 702, the first step is the plaintiffs have to show the court that the court cannot understand the evidence without Mr. Sturdivant's help.
When I look at the evidence in making a decision on your motion, what is the manner in which we weigh the evidence? So if it were a C10, we weigh the evidence in favor of the non-moving party, and we take all logical inferences from the evidence in favor of the non-moving party. When you're filing a motion under MCR 2313C1 and 104A, as you have in this motion, what is your understanding of the manner in which the court considers the evidence?
Well, the standard in Rule 702 is more likely than not. So when
How do we consider the evidence? How do we weigh the evidence?
the court has to determine that it's more likely than not that Mr. Sturdivant's opinion is supported by accurate data. And that's just one of the factors of the 5 factors in Rule 702. It has to be more likely than not that his opinion is supported by accurate data. The plaintiffs bear the burden to walk the court through the data that the expert relied on and persuade the court that it's more likely than not that that data is accurate. So if we go, for example, to opinion number 1, that the defendants operationally controlled the Edenville Dam, again, the first requirement under 702 is that the plaintiffs have to explain to the court why the court is unable to understand emails and letters and deposition transcripts without Mr. Sturdivant's help. They can't do that because the court's perfectly capable of reviewing those documents. The evidence for those documents is all organized and cited to in Appendix 1. We have deposition testimony from employees of Boise Hydro, from the 4 Lakes Task Force, we have sworn statements from the defendants in this case, the staff of the Eagle and DNR. answering that question, who operationally controlled the Edenville Dam? All of them say it wasn't defendants. It was Lee Moeller who ran Boyce Hydro. And the employees who operationally controlled the dam reported to him. That's what they said in their deposition transcript. The plaintiffs have to be able to show the court that the court's unable to understand those transcripts without Mr. Sturtevant's help. They can't do that. The court's perfectly capable of doing this. And the second requirement is they have to show that even if the court needs help, that Mr. Sturtevant is the one who can provide that help. He is not. The plaintiffs concede that he is no expert in Michigan regulatory laws or
Why does
practices.
he have to be?
Because what the plaintiffs are trying to show is that the defendants violated state laws. But Mr. Sturtevant has zero experience administering any of those laws. He has never even operated in Michigan. He's not licensed in Michigan. He's never been subject to those laws. His expertise does not apply to the issues that are before the court. And then you move to the next element, which is that his testimony has to be based on sufficient facts and data. It has to be more likely than not that his testimony is based on sufficient facts and data. His testimony does not even account for the facts in this case, doesn't account for the deposition testimony from the employees of Boyce Hydro who explained who they reported to, the ones who operationally controlled the dam. It doesn't account for the testimony from the Four Lakes Task Force. It just acts like it is not there. And we get insight into how that happened because it turns out Mr. Sturtevant explained he did not do any independent analysis of any of these facts. He simply reviewed whatever the attorneys sent him and then signed the declaration that they wrote for him. That is it. And so he did not know about most of these key facts. So it cannot be the case that it is more likely than not that his testimony on opinion one is supported by sufficient facts or data. And the factors keep going, Your Honor. And this is where the plaintiffs drop off entirely. The last two factors under MRE 702 is that the expert's proposed testimony has to be the product of reliable principles and methods. Not just any principle and method, but a reliable principle and method. Mr. Sturtevant did not identify any principle or method he used to analyze any fact in this case, and plaintiffs have made no effort to identify those. So they do not meet their burden under that factor. And then the fifth factor is that the expert's opinion has to reflect a reliable application of those principles and methods to the data or the facts in the case. Again, Mr. Sturtevant identified no methodology he used to analyze any fact, let alone demonstrate that it was a reliable application of reliable principles and methods. Now, the plaintiffs want to say, oh, we're just bickering about differences of opinion about what the evidence says. That's not our argument. Our argument is that Mr. Sturtevant's opinions are not based on sufficient facts to begin with. This isn't about how much weight the court gives the evidence. This is the fact that his basic opinions are not supported by the facts in this case. And the plaintiffs have made really no significant effort to carry their burden here, to show that each of these opinions satisfies each of the factors under Rule 702. And that's just the first opinion we've highlighted for the court. The second opinion, Your Honor, we follow the same analysis. So Mr. Sturtevant, his opinion is that the defendants forced Boyce Hydro to maintain the normal summer level of Wixom Lake. First of all, back to square one. The court does not need Mr. Sturtevant's help to read emails. The court does not need Mr. Sturtevant's help to read deposition transcripts or letters. Court can do that on its own. And even if it needed help, Mr. Sturtevant has no experience with Part 307 proceedings, never been involved in one. He doesn't know the difference between EGLE and DNR. He's not familiar with their different roles in the regulatory system.
Those shortcomings, if they are, why does that not go to the amount of persuasive value of the particular proffered expert that has been endorsed by the plaintiffs?
That's the same question that the Michigan Supreme Court addressed in the Gilbert case. That's the argument that the plaintiffs in that case made. They said, look, we just have a difference of opinion about whether this person's fully informed. And the Supreme Court said, no, you do not let it in unless it satisfies as a threshold matter, Rule 702, which is that he has specialized knowledge.
Whole defense seems in this case that whatever the state did, they didn't control it. They weren't the guys turning the valves, telling people where to go. And for a year and a half, I have been reading about and listening to the people's arguments of I don't understand how a person who has the professional CV that the purported expert has cannot opine on what the ramifications of, in their estimation, threatening litigation, in their estimation, threatening potentially millions of dollars of fines. And when I say their, speaking for purposes of appellate review for the Court of Appeals and the Supreme Court, when you're looking at the decisions I make in this case, what I'm speaking to my learned colleagues on the superior tribunals from the one that I'm currently serving on is the plaintiff's position. So the plaintiff's position being the state, in their regulatory oversight after the state became the monitoring agency as opposed to the federal folks, that the actions that they took either in conjunction with the Four Lakes Task Force, the discussions that were had on October 2018, when Mr. Trumbull walked around the physical space of the dam, or after in the fall of 2019 and then the spring of 2020, the actions related to whether you would go to run of river flow and height, or whether you would go return, as it had for 98 years, to the ordinary summer level. So what I have understood the defense's position to be that none of those things rise to the level of control. Fair?
Yes.
Okay. How's that not a factual question? Assuming it in the light most favorable, not to the defense that doesn't want the case tried, that believes fundamentally and sincerely that it's entitled to 2116 relief, and also to exclude this particular proffered witness. Why is that not something that a party seeking to meet their burden of proof is not entitled under Michigan law to have a trial and then have the fact finder decide whether it's credible or not? And there may be no value once the evidence has been put through the crucible of cross-examination or tested by other witnesses in either a defense case or a case in rebuttal. But how are we not putting the cart before the horse?
Because Mr. Sturdivant wasn't there. He doesn't have any personal knowledge, Your Honor. The fact that
What expert ever is there? I mean, you know, I was a circuit judge. You've heard me yammer on about it for a year and a half. The only people are more frustrated, not frustrated, who are tired of hearing me talk other than me is you all. I'm sure you are. I would be like, oh my gosh, Redford's going to tell more stories about when he was a circuit judge. But the reality is 200 plus jury trials, loads of them with expert witnesses. I don't ever recall any expert being there, literally ever. Other than the police officers who, based on, a body of case law that existed at that time, they were able to say, offer testimony about what certain things meant drug transaction wise, typically. Short of that, the experts normally aren't there.
Yes, Your Honor, that is correct. He
Okay.
wasn't there. We recognize that. The topic of today's motion is to explain why his proposed testimony doesn't satisfy the exception that would normally allow the court to rely on testimony from someone who wasn't there, who doesn't have any personal knowledge. It is a stringent, difficult test to satisfy under Michigan Rule of Evidence 702. The plaintiffs have to show the court that the court can't understand this stuff without Mr. Sturtevant's help. They haven't done that. Then they have to show the court that Mr. Sturtevant knows exactly what a Part 307 proceeding is, why.
What case says they've got to know what a 307 permit is? I understand in medical malpractice cases, the statute specifically narrows and proscribes who may provide expert testimony. They must be licensed and certified in the subspecialty of the licensed professional against whom an action is being brought. I'm not aware of such a narrowing on the claims that are before the court in the instant matter.
The only reason I'm raising that is because that's what Mr. Sturtevant says is the basis of his opinion. He said the reason he thinks that the state forced Boyce Hydro to return Wixom Lake to its normal level is because of the Part 307 order. And the plaintiffs are accusing the defendants of abusing their authority under that statute. We didn't voluntarily raise that. That's what the plaintiff pointed us towards. That's why we're highlighting the fact that in reality, Mr. Sturtevant did not even know that the Part 307 order did not apply to Boyce Hydro. And he acknowledged in his deposition testimony, oh, I didn't know that. And had I known that, it would change my opinion about whether the 307 order forced Boyce Hydro to do anything. He was not aware. He was not aware that Boyce Hydro and the Four Lakes Task Force independently contracted with one another, separate from the defendants, to maintain the normal of Wixom Lake. He was not aware that Boyce Hydro and the Four Lakes Task Force made a plan independently to maintain the normal summer level of Wixom Lake in the spring of 2020, had nothing to do with the defendants. He was not aware of those facts.
Campbell, do you think if a regulating agent for the state of Michigan felt that there was a potential threat to a serious threat to life or property based on the level of the water behind the Edenville Dam? Forget about the 307, forget about everything else. Would a regulating official have the authority to either immediately direct the owner of the mechanical device holding the water back? When I say mechanical, like, small M, not a machine, but the dam, could an agent order a dam owner to lower the water?
It'll take me a minute to answer your question, Your Honor. I'm not trying to avoid it. But I want to give you an example of how this, I will answer it. That's what I'm trying to explain to you. So yes, is the short answer. Yes.
Okay.
If a engineering report is virtually always how this comes up, says this dam is dangerous, the water needs to be lowered, then Eagle's Dam Safety Unit will typically issue an order requiring it to be lowered. And we're in litigation about that right now in different circumstances where that is exactly what has occurred, where an engineering report has come back and said, hey, here's some issues with this dam. The water needs to be lowered.
But the statute which gives rise to Eagle having the authority, does that have as a condition precedent to taking that action that they must have some type of engineering report?
Well, yes, there needs to be a basis for the government.
Of course, there has to be a basis, but when the legislature gave that authority to the department, did it say you must have an engineering report before you take such action? Because I know the answer. I know the answer. The answer is no, of course it doesn't, right?
The government can't just regulate private property without a basis for
I
doing it.
understand that with crystal clarity. I've read John Locke's second treatise on government. I've read the founding documents, the Federalist Papers, the Constitution, all four constitutions of our state. I get that. However, if there's an emergent situation, can the regulators go in and do something?
Well, yes, if there's a basis, Your Honor. And that's the problem with Mr. Sturdivant's testimony. He says, well, the Eagle Dam regulators should have ignored all those engineering reports. They should have just ignored them. So every engineer up to that point for more than 20 years reviewed the dam, identified the fact that it did not have sufficient spillway capacity, also endorsed it for safe and reliable continued operation. Every single one, even after the license was revoked. FERC had required them to maintain the normal level despite its lack of spillway capacity for decades. And for 90 years before that, it had always been at the normal level despite its lack of spillway capacity. And then, Your Honor, the day the license is revoked, Boise Hydro reaches out to this task force and asks for money so it can continue to maintain the normal level. Mr. Sturdivant does not acknowledge any of this. And so, and Four Lakes Task Force doesn't just give him money. It first says, well, we need to have an engineer look at this. So they hired Spicer Group to say, this dam does not have sufficient spillway capacity. Can we still maintain the normal level? And they said, yes,
Right,
do
but
that.
Mr. Gamble, why? I am having trouble understanding why. Okay, these are very strong arguments, very strong arguments. How is that not the proper subject matter of a trial?
We're not asking for the court to grant a dispositive motion. This is on the motion to test Mr. Sturdivant's opinions. And what we're doing is trying to methodically show the burden the plaintiffs are supposed to show before they can proffer testimony from an expert. They have to show that it's supported by sufficient facts and data. They haven't done that. They have to show that Mr. Sturdivant is reliably using tested true principles and methods to analyze the facts and data. They haven't done that either. They haven't even tried. This is not a situation where we're just disagreeing about the same facts, Your Honor. I've tried to emphasize that. This is a situation where the plaintiffs have a problem. They have Boise Hydro, Four Lakes Task Force, Spicer Group, and the defendant's witnesses all contradicting their allegations. So instead, what they've done, if they hired Mr. Sturdivant, written out their legal claims, and had him sign them, and now they're proffering it as expert testimony that the court can rely on.
Does not Mr. Sturdivant, in the first preamble of his statement, say words to the effect of, this is my sworn testimony, or this is my report? Words to that effect.
They are not his words. He didn't write any of this,
What did he
but
say in his deposition, counsel?
he says that he reviewed it and signed it. That he says, oh, I reviewed it, I agreed with it.
Write something, or somebody writes it for us, that begins with the prepositional phrase of, this is my report. And swear under oath before God Almighty that this is true. And it is your position that that is not my report or your report?
Well, I'll answer that in two ways. The first is that he did not swear. That's not a sworn document. But second of all, that's ghostwriting. He acknowledged in his deposition transcript, he does not know who wrote this document. He reviewed it and he signed it. That is ghostwriting. If federal courts routinely, on the same rules of evidence, reject this type of thing, where the attorneys write up a report and have an expert sign it. That's exactly what happened here. But that's also a separate issue, Your Honor. The issue that we want to focus the court's attention on are these 5 discrete opinions. Each of these opinions has to satisfy or survive the crucible of Rule 702. None of them do. None of them do. Mr. Sturdivant, in his deposition testimony, acknowledged that many of the documents that he thought meant one thing, it turned out meant a different thing. For example, he thought that Boise Hydro had asked to modify the normal summer level of Wixom Lake. And he thought that the defendants told him no and threatened litigation if he did that. Turns out that isn't actually true, and he acknowledged that. He recognized that actually Boise Hydro never asked to modify the normal summer level of Wixom Lake. Defendants never threatened Mr. Mueller or Boise Hydro with consequences of any kind because the request was never made. And he also thought that the state had issued an order to Mr. Mueller and Boise Hydro requiring them to maintain the normal summer level. Turns out he didn't.
2020, did someone from the state of Michigan advise Boise Hydro that a lawsuit was potentially going to be filed over previous lowering, which endangered some type of mussels, mussel, not mussel, but the aquatic life form known as mussels? Did that happen?
I am going to answer your question, but if the court would let me answer it, which is the answer is that there were a completely separate dispute going on about winter levels of Wixom Lake. No one, and so yes, the short answer to your question is that yes, that the defendants were concerned that Boise Hydro had temporarily lowered Wixom Lake and threatened litigation if they weren't willing to reach a settlement to resolve those natural resource damages that they caused. That had nothing to do with the normal summer level of Wixom Lake. They are different tracks, different issues. The plaintiffs have zero evidence from anyone, including Mr. Sturdivant's speculation, that shows that the dispute about the winter level of Wixom Lake somehow compelled or forced or coerced Boise Hydro to carry out the plan that they independently made with the Four Lakes Task Force. Independently conclude, we have deposition testimony from them, we have emails confirming it, we have contracts confirming it. Mr. Sturdivant ignores all that, pretends like it's not there, that says Boise Hydro and Four Lakes Task Force had a contract in place. They always planned to return Wixom Lake to its normal summer level in the spring of 2020. That plan started 8 months beforehand. It came into being without defendants' involvement or even awareness. And so for the plaintiffs to say, well, this lawsuit that was filed 4 weeks after they returned Wixom Lake to its normal summer level, that's why they returned it to the normal summer level. That doesn't even make sense. The lawsuit had nothing to do with the normal summer level. It was a dispute about natural resource damages for a temporary winter drawdown. They are two different things. Mr. Sturdivant recognized that Boise Hydro actually never asked or tried to modify the normal summer level of Wixom Lake. The plaintiffs admitted in their request to admit, it's the only one they admitted, that that's true. Boise Hydro never asked to modify the normal summer level of Wixom Lake. They're different issues. So for Mr. Sturdivant to just speculate, yeah, but I think maybe they forced somehow Boise Hydro's hand. Where's the evidence? He has to show the court that his testimony is based on actual facts. So we laid out the facts for the court in our appendix. Mr. Sturdivant does not acknowledge or address them in any way. And when an expert does not address obvious alternative explanations for the facts that are in a case, that's another reason why their opinions end up not being reliable. So for the plaintiffs to not have evidence from Boise Hydro, they don't have evidence from Four Lakes Task Force, they don't have evidence from Spicer Group, they didn't even depose these people. They don't have evidence from the defendants. The only evidence they're hanging their hat on is this speculation from Mr. Sturdivant in a report ghost written by attorneys claiming that that's what happened when the facts just do not support it. So if they want these opinions to be admitted, they have to show that each one of them satisfies each of the factors of 702. That burden is on them, and they have not met the burden, Your Honor. Your Honor, I do want to put the court's finger on one other issue, which is we really need to keep returning to the facts in the Court of Appeals opinion, because the Court of Appeals opinion laid out the blueprint for this case. They identified what the facts are the plaintiffs will need to prove.
You can argue we just disagree on what the law of the case is. I think you're incorrect as a matter of law on that argument. I don't need, if you want, I've read it. I understand your position. I think it's flat wrong. But if you want to, supplement the record, please do so. The reason it's wrong, counsel, is it's a review of a denial of a C-10. The Court of Appeals, a corrective court that I've had the privilege of serving on for the last 6.5 years, reviews the record as it comes before it. There is a tremendous amount of value from the opinion that Judge Garrett wrote that I am the true beneficiary of. But I don't think it said these are the only things that the plaintiff can proceed on. I mean, what if there was a motion to amend the complaint? Would the subsequent trial court be barred by the law of the case to allow a plaintiff to amend a complaint? And I think the answer to that is clearly no. So your position in your pleadings is, hey, this is exactly what they have to do and how they have to do it, and this is it. There could be a lot of strengths in your case, counsel, in a lot of ways, but I don't, but I'd be happy to listen, but I just don't think it's correct.
Well, I have two things that I would like to say about that on that topic then, Your Honor. The first is to clarify that was a C8 motion, which is not a C10, which is the posture that reached the Court of Appeals. They ruled on it as if it was a C8 motion, not a C10. So, and the second thing to point out is that the Court of Appeals in a published decision did explain what what an inverse condemnation claim is not. And it went to pains to emphasize that a failure to act, failure to take action is not inverse condemnation. So even in the response to our motion regarding Mr. Sturdivant, the plaintiffs repeatedly fault defendants for failing to act. They should have done this, they should have done that, and they just didn't. If they had a negligence case, perhaps against Spicer Group or maybe against some other engineer, I get how that would be relevant information. Here it is not. So their attempt to use Mr. Sturdivant to show what the defendants should have done does not matter. What the defendants should have done or failed to do has no bearing on an inverse condemnation claim, which requires.
If the failure to act is so great that it in itself becomes an action, counsel, it is an affirmative decision by a state agent. And I'm not saying this is what the proofs show, but if the proofs demonstrate that there is a catastrophic failure is about to happen, that there is knowledge of a catastrophic failure about to happen, that the person who is tasked or by job description is given the responsibility to regulate these things. If that person knows all those things and does not share them with the individual who is issuing a permit, and I'm not saying that's facts of the case, but if it were, I'm not sure that not communicating to the next office down the hallway is the same as the failure to act of, oh, we just didn't know. When there is affirmative decisions made not to communicate, I'm not sure, counsel. I don't know that that's what the law of the state of Michigan is. I have read Judge Garrett's opinion with great interest at least a half a dozen times and probably closer to 10 or 20 times. And I'm sure that between now and whenever my responsibilities are completed in this assignment that I have the privilege of serving on, I will read it another 5 times for sure. Because I agree, it is the Rosetta Stone for this case in many ways. It may not be as clear of a Rosetta Stone on the one particular issue you're suggesting.
Well, Your Honor, there is precedent for this that provides all of us with guidance about what sort of act is required. In the Mays case, which is the Flint water case,
Familiar with Mays?
of course, that was an affirmative act. And the fault was put on the defendant or the state in that case because a state employee made the decision to switch. An engineering report told them not to do it and they ignored the report. Now we have the opposite in this case. Now the plaintiffs are saying, oh, you have these engineering reports telling you it's fine to maintain the normal level. You should have ignored those reports and instead refused to grant this permit, which is there's no support for that line of reasoning, that a state agency is liable for inverse condemnation, a constitutional violation, because they ignored decades worth of multiple engineers telling them it was safe to do this thing. And they had no evidence, or they had no basis for independently concluding that it was not safe to do this thing. And then they still grant the permit. That's just not what the precedents guide us towards. The precedents guide us towards some affirmative action where the state deliberately does something knowing it's going to harm somebody. And that's not what the plaintiffs can prove here. The evidence does not show it. And Your Honor, just to bring the court's attention just to this discrete motion, we've got these 5 opinions. Each one of them needs to satisfy each of the elements of 702. And we just do not think there's any way the plaintiffs can show that, Your Honor. So unless the court has any other questions.
I do not.
Okay, thank you, Your Honor.
Desmond?
Good morning, Your Honor. Once again, Christopher Desmond from Venn Johnson Law on behalf of the plaintiffs. Your Honor, I want to start very briefly, and I frankly wasn't planning on addressing this subject because it's kind of a bothersome portion of this motion to me, but this notion of ghostwriting. And the reason why I want to address that, just because I know there is going to be an appellate record made from this, I think it's very unfortunate that the state has elected to use some of the terminology that it has in this case relative to this argument. It has essentially said that Mr. Sturdivant has agreed in exchange for money to serve as a mouthpiece for the opinions of plaintiff's counsel. There's zero reason why Mr. Sturdivant would do that. This is a highly accomplished individual who has worked in the area of dam safety for more than 3 decades. He doesn't need plaintiff's counsel in helping him understand his opinions on any case or crafting his opinions in any case. Mr. Sturdivant was deposed over a series of 2 days, and during that deposition, which was after this expert report was submitted, opposing counsel had every opportunity to cross-examine him and to ask him whether or not any one of those particular opinions referenced in his report doesn't actually reflect what he thinks in this case. Did plaintiff's counsel fool you by putting something in this report that wasn't yours? There's nothing. He identifies nothing in that report that Mr. Sturdivant doesn't believe in. In addition to that, we have the fact that Mr. Sturdivant has rebutted Mr. Trumbull's criticisms of his opinions in this case. And so the state and the defendant, they've had opportunity to confront Mr. Sturdivant as they want to do in the Daubert hearing in front of this court. They've had an opportunity to confront him regarding these exact issues, and he wrote them off completely. He said, "I consider myself to be the primary author of this report because I reviewed it and it reflects all of my opinions." That's in his deposition, Your Honor. So I know, for example, this court said we've all authored documents that aren't actually our documents, that are someone else's document. I served in as a law clerk in the Michigan Court of Appeals for years. Every opinion I wrote,
We write every word of our.
every opinion I wrote was Judge Stevens' every opinion was Judge Stevens' opinion. That's right, Your Honor. Every opinion is Judge Stevens' opinion because it represents what her views are. This report represented what Mr. Sturdivant's opinions were. And if it didn't, it would have come out during his deposition, and it didn't. Very briefly, Your Honor, just to cover this as well, we acknowledge Mr. Sturdivant doesn't have personal knowledge, but like you said, that's not why expert opinions are in cases. In medical malpractice cases, the medical expert wasn't in the operating room when the surgery was being performed. They can.
What do you, the one I would like to hear.
Yes, sir.
Is lack of familiarity with regards to the regulatory, both administrative and statutory construct in the state of Michigan. Why is that not problematic for his capacity to serve as an expert before this court?
I'll tell you a few reasons, Your Honor. First of all, as you referenced, there's no requirement in anything, case law, statute, that says that Mr. Sturdivant has to have that experience. Beyond that, what his declaration, his report does reflect, he reviewed all of Michigan's applicable statutory authorities. He reviewed the National Resources Environmental Protection Act. He familiarized himself with this. And by the way, this isn't an individual. When I say he reviewed it, this isn't the equivalent of walking up to someone on the street and saying, read this, you're good with it, you understand. This is an individual who this is what his job has been for 30 years, is studying regulatory structures, right? And so So with that background information, he's reviewed it. And I think one of the things that's important, and the court kind of keyed in on this when it was asking opposing counsel whether or not at the end of the day, the state has the authority to order the levels to be lowered if they thought that there was an impending catastrophe. Mr. Sturdivant worked in settings where he had that same possible tool available to the government. This idea of we can just order the lake lowered. And in fact, the record shows that he had made that order on numerous occasions, ordered lakes to be lowered. In Michigan, we have MCL 324.31519 sub 1, which is, and this is reflected in Mr. Sturdivant's declaration. He states that Mr. Trumbull should have ordered pursuant to that statutory provision, again, reflecting his familiarity with our laws, he should have ordered that the lake be lowered to run-of-river levels pursuant to that statutory provision.
How do you lower this body of water to run of river?
Well, they had done it previously, Your Honor. They had done it following the FERC revocation of the permit. Before Boyce Hydro had entered into an understanding with the Four Lakes Task Force.
So what does run of river mean to you?
That you're opening the gates to full capacity and you're allowing the water to be at its natural level rather than allowing it to pool up.
This particular dam, how low, if you're looking at the dam from the upstream side?
Okay.
So normally you got a lake
Yes,
before May 20th, May 19th, 2020.
yes.
How much lower mechanically was that device capable of lowering that water?
Your Honor, I apologize. I can't give you the precise number of feet that it would have lowered.
50 feet, 20 feet, 10 feet?
I don't know what the precise level of run of river was. What I can,
Your Honor, Nathan Gamble, yes, I do know. And when the gates were opened as high as they could, it would lower it approximately 6.5 feet because there was still water coming over the spillway. So 6.5 to 8 feet is as low as they could lower it. That's why, Your Honor.
That's
Okay.
fine. Thank you for the information. Don't want another argument just yet. Mr. Dubin?
The spillway crest is 667.8, and if all the gates were open, that is the lowest point. The second aspect is that it was the powerhouse, that if had the turbine was removed, it would have lowered even further. So those are the.
Right, but at some point, when I hear run of river, I hear what this river looked like 98 years ago. And it doesn't sound like that was possible.
Unless you remove the dam to get to that, just like what happened. I think that's effectively the only way that you're going to achieve what you.
All right. Go ahead, counsel.
well, so Your Honor, I think when it comes to the familiarity with Michigan's regulatory system, again, what MRE 702 requires is that an expert's opinions be based on sufficient facts and data in the record. Mr. Sturdivant has explained to this court, he gave the court 45 different exhibits with his declaration. And then in his appendix C to his declaration, I think he cited over 250 other documents that he relied on and that he cited while forming these opinions. So there's certainly data. And if we're talking about our regulatory system, that data includes NAREPA. It includes reading our Natural Resources Environmental Protection Act. And so he's familiarized himself with the data, at least enough that this court can turn any of these disputes that the state is presenting today into issues of weight and credibility. And one thing that I do want to point out is that, I think it's interesting that this is a bench trial. We're having this conversation in the context of a bench trial. And I understand motions to strike and evidentiary determinations are important in any case. But I think they carry a different flavor when we're talking about a jury trial, because a court has to be concerned that if I expose a jury to something that ultimately I decide it shouldn't have heard, now I've got to rely on instructions. And yeah, we can presume juries follow instructions, but there's always that little thing that pulls at you and makes you wonder, did that cause someone prejudice in a trial? Here, where you're the finder of fact, Your Honor, there's no reason why you can't put Mr. Sturdivant in front of you. And if any one of the opinions in question, you determine, you know what, on second thought, that doesn't meet the threshold, you know for a fact that you won't consider it because you're the fact finder. So we don't have to have the same cautionary approach that we may have with certain motions in limine on these issues, because ultimately you're the one who's going to be deciding all of these issues.
I hear you. I'm not sure, my colleagues on the Court of Appeals or outstanding state Supreme Court would agree with you in that proposition. And candidly, if the shoe were on the other foot, I'm not sure you would agree with that proposition. So I do think that we have an essential gatekeeper role. Yes, I think it's easier at a bench trial for the court to just, okay, I'm gonna do I'm not gonna consider that thing that trial judges have to do all the time. And I'm pretty optimistic that I have that capacity, although I'm sure that lawyers who tried cases before me might not necessarily agree with my own assessments of myself, but at any rate, so I don't think we need to spend a lot of time on that. I get that it's obviously a bench trial, but.
Understood, Your Honor.
And I if anybody seeks to exclude evidence because they don't think the other side has met their statutory or common law or administrative duties to get it in, I have no problem with the motion. I have no problem with the people's motion.
Nor do I think you should, Your Honor, but I think that this is an instance where it's difficult for me to understand how we haven't met our burden, and more frankly, why, and this was in opposing counsel's reply brief. There was and I forget what case it was now, but there was a quotation in the brief where essentially it boiled down to ultimately what courts should be looking at is whether this individual will assist the finder of fact. Is it going to help them understand this case better and understand the facts better?
Gamble's argument, at least as I perceive part of it to be, is, and he obviously doesn't need me to speak on his behalf, but as I hear him is, Judge, whatever Mr. Sturdivant is providing to you, he's just talking about the facts, and you've got the ability to decide what that is.
Yeah, and I'm going to say Mr. Gamble has an advantage in making that argument because he gets to talk about how smart you are. And I agree with that. But what Mr. Gamble is saying is, Judge, you can understand all this by yourself. You don't need anyone to help. I understand the court is very experienced. The court is highly knowledgeable.
Right.
Mr. Sturdivant has.
But what Mr. Sturdivant is saying is, hey, listen, you guys threaten this litigation. Judge, you can understand the impact of that. You all, there were emails or meetings that were exchanged between governmental agents. Hey, Judge, you can understand that. I mean, so that's part of his argument.
Sure, but so Your Honor, I don't necessarily know if you want to go through all 5 of the opinions, but just to kind of show the way that I'm thinking about it. When we look at opinion 1, and of course, Mr. Sturdivant doesn't call it opinion 1. This is opinion 1 as described by the state, but this idea of who has operational control of the dam. So Mr. Gamble's saying, well, you can just look at depositions and see, well, who gets to, and to be frank, what his position is, because I read it in his brief last night, was Mr. Mueller has operational control. And here's why. Because Mr. Mueller employs people that he calls operators. And when he wants the gates lowered or raised, he calls his operators, he asks them to do it, and they do it. He's therefore controlling the dam. Well, it's interesting to me that he says that means Mueller's in control. Because the gate operators are the ones lifting and raising. So now what we know from the state is they think that the person who's in operational control is the one who has authority to make those operators move. Well, what Mr. Sturdivant's doing is he's explaining we can have depositions that say a certain thing. But what I'm telling you is at the end of the day, when I'm working with the state of Wisconsin as the state dam safety engineer, I know that ultimately we have control because we have the same sort of statutory provision that Michigan does that says if we want those gates opened all the way to lower the level of risk to surrounding properties, I can order it and we can do it. Another area that Mr. Sturdivant's knowledge could help explain what we see as basic facts according to the state. Things like whether or not the embankment was subject to stability problems and structural failures. The court can look at data if it wants to. How many piezometers were there? Where did the berm connect to? What did the drainage tiles look like? It can look at those data in engineering reports and try to decide for itself, what does this mean? Or it can have someone who's worked in this area for over 30 years sit in this courtroom and be able to contextualize things. And again, as the court said, at the end of the day, you might listen to what he says and you might say, you know what, that doesn't ring very true with me, because I read those reports and I listened to defense's witnesses and I don't think that that's accurate. But is it not going to assist the trier of fact to have Mr. Sturdivant at least available as a resource when we know?
How do you meet the requirement that the opinions or the methodology is satisfies the 702 requirement of subject to being tested, subject to, a review, subject to, I can set up a separate model and have some other hydroelectric engineer take a look at it, and I can be satisfied that that which Mr. Sturdivant did or that which Mr. Trumbull did or whomever is seeking to provide an expert testimony is in fact, it meets the scientific standard.
Right, Your Honor. So this is one of the areas where there's sort of this, you get case law butting into the language of the rule, right? Because the language of MRE 702 talks about needing sufficient facts and data, reliable principles. It doesn't talk about literature. It doesn't talk about being able to test that and recreate what those principles are. Some of that comes from something like Daubert, right? And of course,
Tire,
right, exactly, right, exactly. And of course, our courts, obviously, even though a lot of that is federal law, they've referenced it positively. But even that case law talks about there are going to be certain cases where you're not going to have published literature that's going to tell you these things. We're not going to have published literature, for example, that says who had operational control of this dam. But what we will have is we'll have Mr. Sturdivant's years of experience regarding things like composition.
Historically,
Sure.
my recollection, the case law of, and I haven't looked at it with specificity for today, of what are the ones where we don't have this replicable model upon which the opinion is based, is typically where the model would endanger someone. Would be, like you can't, in a medical malpractice case, you're never going to endanger if an opinion would necessitate endangering a patient. The courts have recognized, of course, we're not going to require that. So I'm not sure that's, in this case, I mean, nobody's asking for other earthen dams to be given way, but there are, at a time I thought I was going to be a naval architect, and I went to the university, two schools that had these massive pools that tested the structure of hulls of vessels, seagoing vessels. And so there are methods and scientific tests available. Well, why shouldn't I require that? And if I did, should I not allow Sturdivant?
So respectfully, Your Honor, I'm not sure there are models like that available for this sort of thing. I'm not disputing what you're saying regarding your past experience.
You weren't here for the first time we met in February of 2024, and I said, this is a complicated case, but mankind has made earthen dams since Mesopotamia. So this has been going on for 5,000 years. I'm guessing somebody's got a model someplace that we could use.
Maybe, Your Honor, but one of the things that I would say to you, and I think this is why someone like Mr. Sturdivant is so important, is because no two earthen dams are necessarily identical. There's a variety of factors when it comes to the type of soil that the embankment is made out of, how heavily it was compacted, how effective the drainage tiles were, how much pressure that berm was putting on that embankment to hold it up. All of these things impact it in a way that I'm not sure how feasible it would be to create a model of something like that. That's the only reason why I slightly push back on something like that. And so there might be certain instances where reproducing a model is what the court needs. But what I think of when I think of something like this is, and this isn't a perfect analogy, but almost more like an accident reconstruction expert in an auto incident, right? You don't have them recreate the accident, and they come in and they admit, yeah, the friction in this case was a little bit different than in this previous one that I worked. But I've worked on enough accidents to know what the general factors are that lead to their cause. And their expert might disagree. He might say that my calculations are wrong, and he can get up and testify in front of the court too. And so Mr. Sturtevant is going to use those exact same models. He's going to say, well, Your Honor, I've worked on X number of dams that had a spillway capacity that was less than the 1/2 PMF, that had an embankment that may or may not have been structurally sound. And here's how we responded as state employees. This is also an individual, by the way. I know I've talked a lot about the fact that he served as a dam safety engineer in Wisconsin for 32 years, but this is also an individual for 10 years. He sat on the National Dam Safety Board, which is an organization that until it fell victim to some of our government spending cuts in the last couple months, this was a board that he sat on for over 10 years, advising FERC and working with FERC on developing best practices with the states. He's a member of the ASDSO, which is an organization, by the way. I think it's interesting that there's been some comment from the state in this case about how, well, Mr. Sturtevant's from Wisconsin, and so why are we relying on him to learn about Michigan? The state of Michigan, after this dam failed in 2020, they went out and they retained 4 different out-of-state engineers from ASDSO, the same organization that Mr. Sturtevant lectures and serves as an editor for one of their technical journals. The state of Michigan hired them to do a review of our dam safety programs. So it's
a matter of record.
I think it's a matter of public record, Your Honor. I don't know if it's in this briefing, but we can certainly get it to the court.
We have so much in the record.
Sure.
I can't imagine that you don't have enough to argue in the record without expanding.
It may be in there, Your Honor. I'm not positive about that. But I think the reality is that until this court identified certain opinions of Mr. Sturtevant as being important to the court's determination on summary disposition, until that happened, there wasn't any indication that Mr. Sturtevant wasn't qualified or the fact that he was out of state was a problem. But once his testimony was suddenly costing the state potentially their chance at a dispositive motion in their view, all of a sudden he needs to go. He doesn't believe in his opinions. He's out of state. He's not qualified. If Mr. Sturtevant's not qualified to talk about these issues in this case, I'm frankly not quite sure who is, Your Honor. There are very few people in this state, including anyone that the state of Michigan is going to rely on in this trial, who have more practical experience than William Sturtevant does. So I don't think a Daubert hearing is necessary. Of course, we will do that for this court if that's what the court wishes, but we believe that this motion can be denied on the basis of the papers and the submissions.
Thank you.
Thank you, Your Honor.
Mr. Campbell, any final comments?
Thank you, Your Honor. Appreciate the opportunity to provide some brief comments at the close here. Your Honor, first, Mr. Sturtevant doesn't cite any of ASDSO's guidance documents. He doesn't cite any independent analysis from anyone. That would be potentially the type of example of a reliable methodology, a reliable principle that the rules require. He doesn't cite to anything that says that state dam safety officials should ignore published repeated recommendations from outside engineers. Maybe that's Mr. Sturtevant's opinion. That's fine. But there's no data really that he cites to support that as a reliable method for conducting dam safety activities. And, opposing counsel said that there's no model, there's really no way to find out if stabilities whether embankments are stable or something like that. There is. In 2015, an independent engineer required by federal law came in, did a very thorough analysis of the Edenville Dam, concluded that based on stability analysis of the dam's embankments, the embankments were safe, in good condition, and that the dam could continue to be safely operated. There is no principle or methodology that Mr. Sturtevant identifies that says that in that circumstance, a dam safety engineer is supposed to just ignore that conclusion from the engineers who have inspected the dam. That's the situation we have here. And just to put the court's finger on a point that Your Honor raised previously about how low you can it was possible to lower the water. The reason FERC, the Federal Energy Regulatory Commission, cared so much about that is because they already determined that it was not possible to alleviate the danger posed by the lack of spillway capacity by simply lowering the water level because the spillway was too small. So that was the point of FERC requiring the extra work. If the dam safety issues could be resolved by simply lowering the water the 6.5, 7, 8 feet that it was possible to do with the existing spillways, that would have resolved the safety issues. But that's the study that we keep pointing the court towards in 2013 that Boyce Hydro's dam safety engineer undertook at the request of FERC to determine whether simply lowering the water level as much as those little spillway gates would allow would alleviate the dangers that the engineers had identified. And they said no.
Where the electricity producing turbine water entrances were on the face of the dam relative to the high water mark?
I do not know, Your Honor.
Do you know how many there were?
On the Edenville, there was just the one turbine.
So there was one opening through which water would enter from the reservoir, spin the turbines, and then thereby generate electricity.
There were two spillways, but my understanding is only one of the spillways had a turbine associated with it. The
Oh, I
other
see.
did not.
Okay.
I actually am open to be corrected by somebody, but I'm pretty sure, I'm almost certain that's the case. There's just the one powerhouse.
My question is, where was the induction area for the water to come in from the reservoir?
I can't answer that question, Your Honor. I would hate to speculate.
No, that's fine. Thank you.
Your Honor, just my final closing is
Please.
just that we put the court's finger on 5 discrete opinions. We're not trying to say that Mr. Sturdivant is an inexperienced dam safety engineer. That's not the point of this motion. Is to say, here are 5 opinions he's offered, and here's how none of these opinions satisfy the 5 factors required under 702 for the court to rely on these opinions when someone doesn't have personal knowledge about that. That's it.
Okay.
So we wanted to make it very focused and very specific, Your Honor.
Thank you. All right, court, I am not going to rule on this until after, I do believe, based on what I've heard today, based on a review of the Michigan court rules and Michigan case law regarding how trial courts are required to address and satisfy our gatekeeper function. We are going to have a Daubert hearing. It's going to start at we can either start at 8:30 or 9, 2 weeks from today, the 25th. Do the plaintiffs have a preference? And don't say 10.
I'm an early morning person, but if the plaintiffs prefer 9, that's fine, Your Honor.
9 o'clock. All right. So we'll issue an order which indicates that we'll begin our Daubert hearing. Plaintiffs, it's your witness, so you'll be going first, just in case. I assume everybody gets that, but just to remove any potential confusion on the logistics of it. So we'll start 0900 on Monday, 25 August 2025. And we'll go for, an hour and a half, what thereabouts, 2 hours, take a 10 or 15 minute recess. Continue. We're not going to take a long lunch recess. So if I'm a little bit hypoglycemic, so I have stuff downstairs or in the cooler here. If you're of the same ilk, then you need to bring a small lunch bag like you would have sent your kids or grandkids off to school with and have whatever you need. So, because we've got a vending machine. If you can satiate your requirements there, that's fine. But if you need something healthy, I'd suggest you do some self-help and bring whatever you need. So we'll do that. Like I said, we will take a recess at some point. I assume we're going to be going a few hours. We'll probably take a 30-minute lunch recess or thereabouts. Continue on at the completion of the hearing, the taking of proofs. If I had to predict right now, depending upon the time of day, if I require additional briefing, we'll break for the day and I'll give you instructions then. If I don't require additional briefing, which if I were handicapping the likelihood of it, I'd say it's at least a 75% likelihood that I'm not going to require additional briefing, probably higher than that, but at least 75. Then we'll take a 15-minute recess and then we'll finish oral arguments on the motion that we've just had our chance to talk about together. If we have enough time, we'll rule on that and then we'll move into the C10. If we don't, then we'll talk about what we do next. But everybody needs to please keep September 15th available. Already told you about August 25th. And that's what I got. Elizabeth or Grace, anything you guys can think of? All right. Anything from plaintiffs? That's all right. Ms. Price, anything else we need to cover before we recess for the morning?
I'm all set. Thank you so much.
All right, thank you, ma'am. All right. Oh, Dan's not here anymore. You tagged off. Okay. All right. Okay. I want to thank everybody for being here today. It's always a privilege to serve you and your clients in this case. I've been spending a fair amount of time since I saw Mr. Dubin last on this matter. It's been a privilege to continue to learn more each day. So thank you. I look forward to seeing everybody in 2 weeks. Court's in recess. Thanks. Please go.